Good morning and welcome to Friday Chalk Talk. My name is Martin and I'm a hospice and palliative medicine physician in Wisconsin. And today's topic is an exploration of the case law involving guardians and end-of-life decisions, and how an understanding of the case law helps us as the palliative care team to appreciate how guardianship agencies may approach end-of-life decisions with us. Today's presentation will be two parts. First, we're going to review three landmark cases from here in the Midwest. And second, I hope to leave you with a few take-home points and questions to consider. So let's get started. All three of these cases are complex, and the Supreme Court justices presiding over them were divided and dissented with each other. And that level of detail just can't possibly be discovered here in this short video. And so in the comments below, I linked to the sites where you can read the full cases, which are admittedly not easy reading, but worthwhile. Otherwise, today I'm going to give you the distilled version. Our first case is of Nancy Kruzan, which is decided in 1990. Nancy Kruzan was a 25-year-old woman when a motor vehicle accident in 1983 left her with severe anoxic brain injury. And despite 4 years of medical care, she remained in a persistent vegetative state. In 1988, 5 years after her injury, her parents asked the Missouri State Hospital to have her artificial nutrition and hydration removed. The hospital asked for a court ruling to grant them permission to take that action. In the end, the U.S. Supreme Court denied the parents' request to remove artificial nutrition and hydration because of a lack of clear and convincing evidence that this is what Nancy would have wanted. The Missouri State Supreme Court did not find the testimony of Nancy Kruzan's friends' past conversations to fulfill their state's requirement to show proof of clear and convincing evidence. And it was really only later, when the parents gathered additional information and brought another case, that they were finally granted that request. So in December of 1990, which was 7 years after her injury, Nancy finally died 12 days after removal of the artificial nutrition and hydration. And the key findings of this case, really germane to today's topic, are: number one, states have their own interests, which include protecting the sanctity and preservation of life, especially with their vulnerable populations. In this case, that was an incompetent patient. One way that states do this is by setting their own standards of what is clear and convincing evidence to make these life and death decisions. Number two, since states get to set their own standards of what is clear and convincing evidence, there may be variation between states. And in fact, there is. The best way that I've heard this conceptualized is like a scale. Some states, like Wisconsin, are looking for a preponderance of evidence, meaning which side of the scale is heavier. But other states, like Missouri, with a much higher burden of proof and ask which side of the scale literally hits the ground. Number three, with this case, there was a recognition in the importance of having documented written wishes, because without one, the burden of proof to show what is clear and convincing evidence can be steep and not worth the risk sometimes. And number four, the U.S. Supreme Court shifted the control of these decisions about end of life to the state level. And this sets the stage for Wisconsin to see two cases of their own in the next 7 years. So our second case is of LW, which was decided in 1992 in the Wisconsin Supreme Court 2 years after Nancy Kruzan. LW was a 79-year-old man when he was appointed a corporate guardian in 1989. He had schizophrenia and had been institutionalized since the 1950s. There were no close relationships or family to provide any substituted judgment, and it was presumed that he may have never been competent. In 1989, he sustained a cardiac arrest, leaving him in a persistent vegetative state. Medical teams asked the guardian to grant them permission to withdraw life-promoting medical treatment, which included artificial nutrition and hydration. It was the guardian that asked the court to weigh in if a guardian had such authority here in Wisconsin. And the court ruled in favor of the hospital and granted the guardian that authority. And here are some of the excerpts that are taken from the case itself that highlight some of the key findings in this case. We conclude that an incompetent individual in a persistent vegetative state has a constitutionally protected right to refuse unwanted medical treatment, including artificial nutrition and hydration. The right to refuse unwanted treatment must be extended to those who have never been competent. That a court-appointed guardian may consent to withdraw such treatment where it is in the best interest of the ward to do so. and that the guardian does not need the prior authority of the court. In some circumstances, it may well be in the patient's best interest to have treatment withheld or withdrawn. A dignified and natural death may outweigh the interest of maintaining a physiological life as long as medically possible. In making the best interest determination, the guardian must begin with a presumption that continued life is in the best interest of the ward. Whether that presumption may be overcome depends upon a good faith assessment by the guardian. This interest weakens as the degree of bodily intrusion increases and the chance of recovery wanes. And finally, we stress that this opinion is limited in scope to persons in a persistent vegetative state. Now, this case of LW is particularly narrow, offering guidance for guardians if their ward is in a persistent vegetative state. I don't know about you, but I don't meet many patients who find themselves in a persistent vegetative state. And so this brings us to our third and final case. This is the case of Edna and F, decided in 1997, 7 years after Kruzan, 5 years after LW, also heard in the Wisconsin Supreme Court. Edna MF was a 71-year-old woman with Alzheimer's dementia, living in a nursing home and receiving nutrition via a peg tube. She was immobile and bedbound, unable to follow commands, nonverbal, incontinent, able to open her eyes, no purposeful response or interaction other than her ability to withdraw pain. In 1995, given Edna's severely dependent condition, Edna's guardian, her sister, petitioned to have the artificial nutrition and hydration withdrawn. Edna's guardian, her healthcare team, and the nursing home ethics committee convened, and all were in agreement that withdrawal of artificial nutrition and hydration was in her best interest and that life had become, quote, suffering. But the nursing home wanted to have all known family to have documented a written agreement with this decision, and since one niece refused, the guardian had to file a petition to the court for withdrawal. The key issues for us brought up in this case were, can a guardian withdraw artificial nutrition and hydration in a person not in a persistent vegetative state? And was there enough evidence to support that this is what Edna would have wanted in these circumstances? The evidence that her sister brought was based on an end-of-life conversation Edna had with her mother and her sister 30 plus years prior when her mother was dying from cancer. In the circuit court, in the US Supreme Court, or the Wisconsin Supreme Court, both denied the guardian request. And there were several different arguments as to why, but we're going to examine the main one here, again, taken right from the case. Even though Edna is not currently existing in a persistent vegetative state, if her guardian can demonstrate by a preponderance of the evidence, a clear statement of Edna's desires in these circumstances, then it's in the best interest of Edna to honor those wishes. The reason this court requires a clear statement of the board's desires is because of the interest of the state in preserving human life and the irreversible nature of the decision to withdraw nutrition from a person. There's a presumption that continuing life is in the best interest of the ward. The only evidence in the record of Edna's desires is a general statement she made to her sister in 1966 or 1967. We understand how difficult Edna's illness has been on her loved ones, and we sympathize with their plight, but the evidence contained in the record is simply not sufficient to rebuke the presumption that Edna would have chosen life. And so we learn from this case that the court grants clear authority to guardians to act when they're using either, number one, substituted judgment, but only if there's an advance directive or previously known clear wishes to act on, or number two, based on the best interest of a person, but only if they're in a persistent vegetative state because of the precedent that was set by LW. In this case, Edna fell between the cracks, not having a clear enough past statement, or at least according to the court, not having a clear enough past statement, and not being in a persistent vegetative state. So where do we go from here? We can appreciate the limitations. We have very little case law to draw from, just two cases that are now 20 to 30 years old here in the area. It's difficult to extrapolate from other cases or to other cases when you can change a few facts which might result in an entirely different ruling. And I've seen guardianship agencies, ethics committees, and legal teams take different interpretations of what LW and Edna and F mean. We can appreciate the history. At the very least, just appreciating the existence of these cases can be helpful in us understanding where guardianship agencies are coming from, rather than getting frustrated with a guardianship agency that may be making a decision that we think is in conflict with the patient's best interest. And it also helps us to understand the summary statement provided by the Wisconsin Department of Health Services, which I will link below. We can ask for clarification. When I'm working with guardians, I'm upfront with asking them, how do they interpret their role? How do they interpret the law? What limitations has their agency put on them? And also, specifically, how do they view physicians making unilateral decisions? How might I be able to help take some of that decision off of their plate? And my final point here is to bring this full circle to my title and leave you with a question to consider. Is it better, or when is it better, to ask for forgiveness rather than permission? We now have seen 2 or 3 cases where going to the courts to ask for permission to remove life-prolonging treatment ends up prolonging the patient's suffering, and that permission is not granted, or at least not initially granted. And there are more cases like that out there. Asking a court for permission instead of making a unilateral decision poses potential risk of eroding the physician's autonomy and professional judgment to limit care that's inappropriate. Hence my question of, when is it more prudent to act rather than to ask? Anecdotally, I've been involved in such cases where I've met with guardianship agencies where their policy has been that they will not sign off on a DNR order or withdraw of life-prolonging treatment. However, some have also shared that they will not actively oppose us if we unilaterally make that decision for them, in cases where it's appropriate and professionally reasonable for us to do so when we're approaching medical futility. So, thank you for your time today. I hope I've left you with a few things to consider, and have a wonderful rest of the week. Take care.